Texas uses guideline child support. What does that mean? That means they're going to look at your check, and then based on the number of kids you have, it's a percentage. For instance, if you have one child, it's going to be 20% of your income minus some deductions, like taxes and maybe some union fees. And when you have two kids, 25% of that. And it goes on up. And it's important to know that in Texas, we used to be able to do a thing where we had child support and you would pay your spouse directly. However, the state law changed, and now the judges don't sign off on those. So it's going to come out of your paycheck. And there's two ways you can do that. You can send it directly to the Office of the Attorney General, or you can do a wage withholding, and that's where they just garnish it directly from your check. I always advise my client it's best to get that wage withholding set up. That way you don't have to worry about being late with your payments. It's going to come out automatically out of your check. You're going to get used to the amount it is, and you have a record of making those payments, and you don't have to worry about somebody crying that they didn't get their payment when indeed they did. That's the best way to do it. In Texas, a divorce, the timeline is very different depending on each case. I do uncontested cases where I'm the only lawyer and I'm just shuffling paperwork back and forth to the parties. In that situation, I can get that done in as fast as 61 days. In Texas, we have a 60-day waiting period, meaning that your divorce can't be done before 60 days. But on the uncontested route, we're usually getting those done between 61 and 70 days. Now, it depends. If you and your spouse are fighting, this could take a lot longer. On average, cases where there's a little bit of contested issues, the cases are usually running 6 months to a year. Now, believe it or not, I've had cases go over a year, almost 2 years. However, the state legislature is cracking down on those judges and keeping up with their timelines a little better. So cases are starting to wrap up a little faster again. So I think on average, you can expect your case to finish between 6 months to 12 months. And the process is quickly, I guess you could say, you file a petition, you go to mediation. If you reach an agreement on temporary orders, then you stop there and you go as is until you have another mediation to see if you can settle on final orders. And if you do, you're done. If you don't agree at that first mediation, you're going to go ahead and go to court for a temporary orders hearing. You're going to get some rules in place that you're going to live for a while. And then each attorney is going to be sending out requests for documents so that everybody knows what everybody has. And then if you don't settle at that last one, you got to gear up for that trial. So the ones where there is no settling at the mediation level, those are going to be the ones that are going to last a lot longer because you're waiting on the court's availability and you're also fighting back and forth. Well, you didn't give me this document. You didn't give me that one. And then you're going to court hearings about who didn't give whom what. So it really extends the process and the cost. A lot of my clients in my divorce cases think that if the other party is cheating, they automatically get everything. Unfortunately, in Texas, that's not the case. Usually, if you can prove adultery, infidelity, what you get is maybe a 1% to 2% bump of the division of the marital estate. So let's say if the court was going to divide your case up 50-50, they may give you 51% or they may give you 52%. Now, another misperception would be that moms always get custody. Well, the numbers will say that a large number of mothers do get custody, but it's not automatic. Dads have rights too. There's a lot of dads out there that are going to all the events for the children, that are taking the kids to the doctors, that are doing the homework, and they would be a better parent. So dads, you can fight for custody and you can win. You just need to show that you're the most stable, responsible, and you're the best person for that child to be the primary caregiver. It's important for divorce clients to think about their finances before they even file for divorce, because you're going to be going from a 2-income family to a 1-income family. So it's important for you to know your income, your debts, your assets. If you don't have a bank account in your own name, I'd go ahead and open up one in my own name so you don't have to worry about somebody withdrawing all your money out of there before the divorce starts. And then the more you know and the more you're prepared to understand what your financial situation is before the divorce ends, the less stress that you'll be under the whole time, because you already have a plan and know that financially you'll be able to make it. Finances is a big stressor for people when they're going through the divorce because of the loss of the income, because of the expense of the divorce. So it's important to have that all worked out in your head so that you can have peace of mind and focus on the important issues, the kids, or the division of that property. And you can do it with a rational mind and get through this case a lot easier. In divorce cases, mediation is a requirement in the areas that I practice. A court will not hear your temporary orders hearing or hear your trial unless you've attended mediation. Now, the beauty about mediation is it's you and your spouse, with your lawyers, of course, and a third party neutral who's trying to get both of them to come to an agreement. In mediation, it seems nobody really wins mediation. Mediation is about what am I willing to compromise on to get this done? And why is that important? Because these are compromises that you and or your spouse can make during the mediation process. And you're not going to rely on a judge to make these decisions for you. That's going to affect you for years and years. In a temporary orders hearing of judges, they vary in time that they allow you to have that. Usually it's an hour and a half to 3 hours. And that's all you get to decide who has temporary custody, who gets kicked out of the house. So if you and your spouse are in control of this and you're making the decisions, you're not leaning on somebody else to make a decision after they heard you only for a short time. And also, it saves you in cost, it's more efficient, and it's a lot faster if you can mediate the case. Now, not all cases are going to settle in mediation because the parties are so far apart, and you don't want to give the other party your worst day in court in mediation. So if both parties aren't willing to settle and negotiate a little bit, then you're probably going to go to those hearings. But if you can get it settled, and like I said, most cases do settle in mediation, it's better for the pocketbook, it's better for the stress, it's better for everybody.